Out of the gate, you've got to understand the concept, and you were kind of hitting on this when you're talking about prenuptial agreements, which is the concept of marital property versus separate property. All right, marital property is anything really acquired during the marriage, right? So when you become one person in the state of Missouri, I mean, you are technically, when you get married, you become one person under the eyes of the law, right? So, I mean, I'm married, my wife's my law partner, right? And in saying that, I could go home tonight, let's say, and hit Powerball. I could go get that ticket and hit Powerball and hit it big and say, I'm going to keep all that money. That's my money, right? I hit Powerball, my good. That's it, right? No, we won Powerball, not me, right? We won Powerball, right? You could get a big raise and be married and say, I got a big raise. No, not you got a big raise. You all got a big raise, right? You are one person under the eyes of the law. You are one person, right? And really the only way around that is what you talk about with the prenuptial agreement. Absent that, you are one person. It's like you formed a corporation with each other, right? And I've had situations where maybe people got family business, but it's really one person's family business and the other spouse isn't really that interested in it. And they're just like, hey, I'm just going to wipe my hands from it and watch it. They can go down the tubes, who cares? Well, you should care because you're married. And if that thing goes down the tubes, yeah, you're both on the hook for it.
There's a general presumption you start out with everything's marital property. Right. Then here's exceptions. So the general rule is, yeah, it's all marital property. Now what are the exceptions? And that's where it really can get complicated.
Right. But the starting point is potentially marital property. Separate property is this, which is property that you brought into the marriage, property acquired in exchange for separate property. So maybe you argue that here. You say, well, I had this money before marriage and I bought this thing with money I had before marriage. And if you can trace that and you didn't commingle it with marital money, then maybe you can make that argument here. Remain separate by agreement, prenuptial agreement, or an order of legal separation, or property acquired by gift or inheritance, right? So you don't get the engagement ring back, right? You give an engagement ring. Your spouse cheats, say, I want that ring back, I worked for years for it. It's a gift, right? It's a gift. Same with, birthday gifts throughout the marriage, anniversary gifts, I mean, it's a gift. Inheritance, if you alone are mentioned in a will and something's inherited to you, that's your separate property. But, there's always a but, but there's some things you can do theoretically to mess it up. If it's your separate property, like you can commingle it, which means, let's say you had a bank account, and let's say, I'm just throwing numbers out, let's say a bank account, you had $10,000 in it, right? And you had that before you're married, right? And then you get married, you put your spouse's name on it, your spouse put the $10,000 of their money into it, now you've mixed the whole thing up, it's commingled at that point, it's like a salad, you threw it all in there, nobody can really differentiate whose is whose, that's commingling. Tracing can happen. Tracing is an important thing in a lot of cases, especially high asset cases, but we will use what's called forensic accountants who will come in and will be a tracing expert for us. So take like an investment account that maybe a party had before marriage. So you come into the marriage, you have $100,000 in an account, right? Then you get married, you start putting more and more money, and then that thing's growing, and then there's dividends and interest being accrued and all this. In some cases, it becomes so commingled that you really need a forensic accountant, a tracing expert to come in and say, Judge, of that $100,000 that he or she had coming into the marriage, we can trace out, whatever the number is, 90 or 95,000. That is still that distinct money that should be apportioned to them. But the way it works in Missouri is if you don't have an expert who can trace that thing out, then once you've commingled and mixed that stuff up, yeah, it's marital at that point. Transmutation, I guess I don't have on the slide, but that's another, I guess I would call that the other issues. Let's say you own a house, before you're married, it's in your name, right? And you get married, and then you go and put your spouse's name on as well. Now you've transmuted it. It was originally separate property, but by putting your spouse's name onto it, you've now turned something that was separate, and you've made it marital. I mean, then you get to other questions past that, which is how long you end up staying married before it leads to divorce. You get all these other complex questions. Theoretically, it's still your separate property, but where it can get complex and people can still mess it up is, let's say you do this. Let's say you own the house, it's in your name, you never put your spouse's name on it, but then when you get married, you get a joint bank account. She puts her paychecks in, you put your paychecks in, you start paying the mortgage out of that joint bank account. People do that, and that's how they can mess it up. Because at that point, that spouse says, wait a minute, still my paycheck was going to pay that mortgage. I'm entitled to a piece of it. So that happens in some cases. Or the spouse, I've had this case, where the spouse's name never goes on it, but they put a new bathroom in. And they put their own money into it, or a deck gets put on, and they put some of their money into it.
Wow.
All that stuff can mess it up. Right, all that stuff can mess it up. And so, and that's what, these are the kind of issues that cause people to go to trial. It can mess it up. I know, it's complex. It's a headache. I know. Is property always divided 50-50? I hear all the time. Which is why I need an attorney. Judge is going to divide it 50-50 anyway, right? 50-50, right? And then they just take a knife and just cut it right down the middle, and it's good, right? Right? The problem with that is the judge doesn't have to divide it 50-50, and stuff isn't always divided 50-50, right? I think on a practical level, most judges are kind of thinking 50-50 somewhere in there, but just like custody, it doesn't have to be, the judge is going to give the kids, each of us 50% of the time, not necessarily, right? Property debt is nowhere in Missouri law does it say the judge divided 50-50. Here's the statute. 452-330 is the statute. And it says a proceeding for dissolution of marriage or legal separation, or a proceeding for disposition of property following dissolution of marriage by a court. And we'll skip to here. The court shall set apart to each spouse such spouse as non-marital property or separate property, right? So if you've got separate property, get that off the top. And then the court shall divide the marital property and debts in such proportions as the court deems just, after considering all factors. So you've got a really problematic term like just. Like, what does that mean?
What does that mean?
Just. What's just to me might not be just to you, right? What's just to Judge A might not be just to Judge B, right? Judge B might have a totally different view on it. What's just to the husband might not be just to the wife, right? I'm going to diatribe about that, but I can't tell you how many cases, you just knew if you were a fly on the wall on the other side of the case, and the conversation would go something like this. Because my clients say this all the time. Let's take hypothetical, say I have a wife. My client will say, Kirk, if only my husband would be reasonable. I put a very reasonable settlement proposal on the table, and if only he would be reasonable, like we could be divorced tomorrow, right? We could quit spending all this money on attorney fees, and we could be done. We could both move on with our lives. And my proposal is totally fair. And I'm sure husband sitting in there with his attorney, husband saying, if my wife would only be reasonable, I have put a very reasonable settlement proposal on the table. And if she would just take it, like we could just be divorced like tomorrow, right? I mean, come on, let's just be reasonable. Why can't we all just be reasonable? And that kind of comes down to this inherent topic. I wrote an article, and the title of it is Reasonableness is in the Eye of the Beholder. Which is what's reasonable to you might not be reasonable to me. What's reasonable to the husband might not be reasonable to the wife. Everybody thinks their own position is reasonable in life, right? And they think everybody else is totally unreasonable, right? And that's unfortunately the way this thing works. But this term just is a big problem because it doesn't say 50-50, it says just. And that creates a lot of uncertainty in terms of what a court does. So again, the common myth, judge just divides it 50-50. No, they divide it when it's just. Just could be 60-40, could be 55-45. Could be 65-35, it could be all kinds of things. Can't probably be 100-0, that would be unconscionable, as we talked about, right? But within just, it's wide open in terms of how that could break down.